Hello everyone. Welcome back to another session of the NCCER safety training. We're going to be in the safety technology book this evening. We're going to be in section 16, module 75216. So that's module 16 in the safety technology book, and we're going to start off at page 16.1, folks. Okay, so if you can go ahead and turn there for me, and let me tell you what we're talking about tonight. All right, we're going to be talking this evening about the OSHA inspection procedures. And we're going to be talking about the process, what you can expect if there's ever an OSHA inspection at your facility. All right. So first of all, what happens, right? I'm at 1.1.0, which is page 16.1 on the right-hand column, folks. OSHA periodically inspects work sites, right? And the reason they're inspecting them is to make sure that the safety standards are being met. They want the safety standards obviously to be met in order to be able to protect the human right, employees, and then also the general public as well, because by protecting employees, we're also providing protection to others like visitors or the general public that may be in a work site as well. Um, so what happens, right? Basically, we definitely want to have a good safety management program. That's going to be one of our best defenses against fines. And ultimately, why are we fined? Because we're not being protected, right? The employer is not protecting the employee in the workplace or the employees in the workplace. So if we have a written program and a competent person on site, the company is going to go ahead and could possibly qualify for limited inspections. Nowadays, where you tend to see limited inspections is in the VPP programs and the STAR programs as well. So let me show you what I'm talking about. All right, folks. I'm going to take us over out of the internet, out of the PowerPoint, and let me go ahead and take us to OSHA. Let's see. Let's try limited inspection programs first. If not, we'll go to VPP. Okay, let me go to VPP, folks. It's here you go, voluntary protection programs. This is what I'm talking about right here. And basically, what happens is that OSHA back in the early '80s, 1982 to be specific, they went ahead and created this voluntary protection program. And basically, what it does is it recognizes, right, and it partners with certain businesses. A lot of times, it's larger manufacturers, larger refineries as well, oil and gas facilities, and then of course some servicing companies these days as well. And it basically what it does is that they go through a whole process of going ahead and going through the verification programs to make sure that they have the right health and safety programs in place, also to assure that they are complying with OSHA standards and going through evaluations, inspection processes as well. Okay, so the VPP program, there you go, and this is just a perfect example. And in this VPP program, as you see it right here, is that you'll have different levels as well. Okay, you'll go ahead and have the star and the merit, and there you go. Okay, and those are often the programs that you see in the VPP programs. So if you ever see it, let me show you what the logo looks like if it's ever a facility that you're looking for, to see if they have it or not, or just so you can recognize it. Let's see. Okay, there you go, folks. Right, and some of you may have seen the Sharp program. Let's see. Here we go. Sharp program. Also, the like I said, the VPP program as well. Okay, and then you have the star as well. You see the star there as well. So those are different programs, and basically what it's showing is that it's showing that these facilities went and took the additional measures to make sure that they're compliant with the OSHA standards. A lot of times, also it may be best practices, and what happens is that they are reduced to limited inspections only. Normally, it's in case of a fatality is usually the greatest reason, and then it may be for significant or still some imminent danger as well. Okay, so let's talk about OSHA inspections for a little bit. So go to 2.0.0200. So OSHA representatives, right? They're called CSHOs, folks. That's Compliance, Safety, and Health Officers. And basically what they are is they're federal representatives. They inspect job sites, right? And basically what they have a health and safety background, or they're educated into the health and safety background in order to make sure that the companies are following the health and safety standards and following the safety regulations as well. So basically what will happen is before CSHO, right, or a compliance officer comes to our facility, what they're going to do is they're going to go ahead and get some historical data on us. So they're going to check and see if we've been cited, previously been cited, our organization or our company. Also, in addition to that, they may possibly also check to see what we do, what industry we're in. Okay, and they may even be targeting us because of the industry that we're in. So let me give you an example. Okay, is it's an let me go and pull this up for you. Let's see. What'll happen often is, let me give you an example of this. So let's say tower climbing. Okay, tower climbing is a really risky industry, and there've been a number of injuries and fatalities. Way too many fatalities for the number of employees that are actually in the industry. So what's happened is that OSHA basically put out an industry emphasis plan, going out to check jobs where tower climbers are doing work. Okay, so what happens? And let's use that example, and let's use a shipyard, especially a shipyard, because shipyards are static. So, and when I'm being static, I mean they are in the same place all the time, and we can pretty much expect the same type of process to be followed most of the time. And this is what I'm talking about. Usually shipbuilding, right, or either shipbuilding, shipyards, or and if not, some maritime facilities, and if not, it may be oil pumping, or loading and unloading intermodal containers. So let's see, shipyard, and let's do terminal operations. Items like this, like moving cargo containers. They're also their technical name is intermodal containers, because you can move them from vessels to trains to 18 wheelers. Okay, so all of this is terminal operations, is what we're looking at. That, and it could also be pumping like product from tank farms as well. So let's see. So it'll be pumping off of vessels, and bringing it back into like refineries or tank storage farms as well. Okay, so that just gives you a different idea of different industries, right? So what'll happen often is, let's say if OSHA wants to inspect a shipyard, and what they can do is this: they'll go to the Bureau of Labor Management, and they'll basically find out what the NAICS code is. And let me show you how this works. NAICS code for shipyard. What it is it's going to be a unique 6-digit code, and the code actually is determined by what type of business we provide in this country. So let's see, and for other developed countries as well. Let's see this code for shipyard. Let's say. There you go. So our NAICS code, we can go to census.gov, but I just want to do the easy way right now. It's 336611. That is the NAICS code for shipyards. So if, let's say if I'm an OSHA inspector and I want to go check shipyards in Texas, right? Well, what I would do is I would tell the Bureau of Labor Management or the Bureau of Labor Statistics that I want all organizations that have the NAICS code of 336611, and I want them all in the state of Texas. Or let's say if I'm in lower Louisiana, right, like around the greater New Orleans area, the Bayou region, or something like that, I can tell them that I want anybody in 336611 that has a zip code that starts with 70, and that's the southern part of the Louisiana state, the state of Louisiana. So these are different ways that OSHA can kind of go to our industry, to our organization, if they're looking for inspections in our particular industry. Okay, they could also be random. And we've talked about this previously, especially if they see cranes operating through the air, scaffolding. Anytime they see items like that, a lot of times that'll be a trigger where OSHA inspectors may just drop in. Okay, people on rooftops. So because why? Because the greatest risk in construction is falls. Okay, so let's go ahead and talk. We're going to talk about 210, which is the cause of OSHA inspections. Okay. Okay. So basically, what's going to happen is that often OSHA is going to schedule an OSHA may wind up scheduling an inspection when it's necessary, right? Usually, the majority of the time, they're just going to come out to the work site and they're going to come visit, and they're going to ask if they can go ahead and do a walkthrough, basically, okay, or an interview with us. So let's talk about what the normal steps are in an OSHA inspection if OSHA comes out. Like I was saying, normally OSHA does not normally announce that they're coming out ahead of time. However, there are some reasons why they potentially would, okay? The primary reasons that they potentially would advise an employer that they're coming out is because, first of all, they think something is in imminent danger. It basically means that they believe that someone or a group of employees, their quality of life or their life period may cease to exist because it's such a significant risk. So at that point, OSHA will often call the employer, ask them to stop operations or stop work, sometimes take pictures and document, and advise that they're going to be coming out in the next day, that day, the next day, or series of days, okay? Just depending on how quickly they can get to that site. So usually they'll call for imminent danger. They'll also call if they got a historical relationship with the facility and they know that the safety manager has to be there or the plant manager has to be there. It may be that they know that the attorney for the facility has to be there as well. So those are all reasons why it's basically a reasonable delay or notification in advance. So the employer may ask OSHA to wait a little bit longer to get on site, usually in a matter of hours, or they may go ahead and OSHA may call and coordinate and say that they want to go in, or it could be something where it's a 24-hour operation, but that all the senior management, supervision, and safety, maybe the majority of them only work during the daytime, but they want to go in and inspect nighttime operations at a facility. Okay. Okay, before moving on, I definitely want to address this, is that if you're ever in a position where you get a phone call from OSHA, the only people you should be contacting is your immediate chain of command. You shouldn't advise anyone else on site that OSHA's coming out. You shouldn't advise anybody else that there may be an inspection, because what happens is that it's actually citable and finable through OSHA, where we individually can be cited up to we can be penalized up to $1,000 for giving advance notice that OSHA's coming out, and it could also be up to 6 months in jail. Okay, it's a misdemeanor crime. Okay, so let's go ahead and talk the reasons why OSHA would come out. And in this situation here, uh, you'll see that there are 5 different reasons why OSHA would come out as per the NCCER material. Often, a lot of times, it's broken down nowadays into 4. It's very common practice to break it down into 4. But let's go ahead and talk about all 5, and then I'll kind of show you which ones are being blended together. Okay. Okay. First and foremost, the main priority that OSHA would inspect would be imminent danger. What does imminent danger mean? It means somebody's at risk of dying or significantly getting hurt today. Okay, either an employee or a group of employees, but there's a significant amount of risk. So we're concerned that somebody may be harmed today. So therefore, that's going to take precedence over all else. The second one is the result of the inspection after a catastrophe or a fatality. And basically, what happens is that if there's anybody who dies in the work site, or if there's a catastrophe, which is normally the hospitalization of 3 or more for the same incident, like 3 from a scaffold fall, 3 from the same carbon monoxide poisoning, that is called the catastrophe. Nowadays, we even report even just 1 hospitalization, so the catastrophe term isn't used quite as much anymore. Um, so the first one's imminent danger. The second one is a catastrophe. The third one is a complaint. It could be a complaint from an employee. It could be possibly also a referral. It could be a referral from another government agency. It may be the EPA. It may be the EPA. It may be a complaint from another referral from another employer, maybe, and usually it's supposed to come from employees from the company for which they work. But if it's something significant enough, they may come out because of a referral or a complaint like that as well. Okay, from maybe another company on site. The fourth one is programmed inspections. Basically, they've planned to go ahead and come out to the facility, and that could be. And then the fourth one is follow-up inspections, basically meaning they've come up before. For some reason, they want to come back out again. Maybe they want us to take some corrective action. Maybe there's something they're looking at that they can't quite place their finger on it to see if there's a significant risk or not. So just depending. Okay. So let me tell you what happens. Right? Is that it used to be 4. I'm sorry, it used to be 5. Now it's, like I said, it's more classified as 4. So imminent danger, number 1, catastrophe and fatalities, number 2, complaints and referrals, number 3, and 4 being programmed inspections and follow-up inspections. Okay, so that's how it pretty much runs now. All right, so what happens, right? So OSHA gets to the work site, and basically, first of all, we've got to let them in. We're required to let them in. So what happens is that we can ask them to wait, but like I said, it's got to be with reasonable delay, right? Supervisors got to get there, plant managers got to get there, attorneys got to get there, whatever the case may be. We can't ask them to come back Tuesday, right? And today's Sunday. We can't ask them to come back tomorrow. They're going to want to get in today. What they don't want us doing is changing any of. They don't want us changing any of the facility, right, or staging anything. They want to basically see the environment in its natural state to see if there's any requirement, any significant risk that they need to be concerned about. Okay, so let's talk about when does OSHA, what the process will be, and what you can expect if you're going there. So if OSHA's coming out to us, these are the 4 steps. Take a look. I'm sorry, the 5 steps. Take a look at the 5 steps. And again, I'm going to tell you how they've been kind of merged together. Okay, so just read those 5 steps, and then I'm going to give you, again, give you a little background on them. Okay, so what happens is this, right? The first thing that the OSHA inspector will have to do is present their credentials. Now, when the OSHA inspector presents their credentials, we cannot photocopy them, but what we can do is ask for, what we can do is go ahead and ask to view them. All right, we should get the identification number off of them. And by doing so, we should call to verify that it's true and accurate. What I tell people, is that don't call the number on the card, although the number on the card will probably be the 1-800-321 OSHA on their identification, but call the actual OSHA number. And again, it's 1-800-321 OSHA. That is their number, okay? So let them present their credentials. And the thing is, nowadays, especially like most of us know, it's so easy to falsify documents and identification cards. So you definitely want to make sure that it's somebody who's not playing a joke. It's not corporate espionage. It's not somebody who found the ID because it was lost or stolen, lost somewhere or stolen out of the person's personal belongings or property. Okay, so verify it. And they understand that the OSHA inspectors do understand that we should be verifying this information as well. So, like I said, the first step is presentation and verification of credentials. The second step is going to be the open conference. During the opening conference, that OSHA inspector is going to tell us why they're there. They're going to tell us, did they get a complaint, right? Are they responding to imminent danger? Are they responding to a hospitalization or a fatality? Are they there for a subsequent checkup or a routine inspection? So, biggest thing to remember is this: is that they will tell us while they're there, and it's basically like it's the equivalent of being pulled over on a traffic stop, and law enforcement officer basically giving you their probable cause. Okay, so the third step, as per NCCER, is selection of representatives, basically determining who's going to do a walkthrough with the OSHA inspector, okay, and where they're going to walk through and what they're going to do. The fourth step is the actual walk around. Now doing a walk around or inspection, okay, throughout the facility and throughout where the inspectors asking to go and where they're also allowed to go as well. Okay, and then the fifth is the closing conference, which basically they come back. They may or may not tell us what they found. They may ask us to fix some things along the way as well as they're walking through, and they'll basically kind of finish telling us how the process is going to work and what we can expect. So let me tell you what happens in most cases. Most of these now have been they've been merged into 4. And step 1 is the presentation of credentials. Step 2 is the opening conference and the selection of representatives. All that happens now during the opening conference. Step 3 is the walkthrough, and step 4 is the closing conference. Okay, but since NCCER has got it as 5 for the purposes of this course, we're going to go ahead and stay that way. Okay. So great. So there's a few more tidbits information in there in those few paragraphs. But like I said, that's the bulk of basically what you can expect during an OSHA inspection, okay, from a compliance officer. So let's say that the compliance officer finds hazards, right, and violations. They do not cite on the spot. What will happen? They do not penalize on the spot. What will happen is they may ask us to fix the issue there. They may also tell us that they need to get, or that it's going to have to be fixed, and they'll probably tell us that they have to go back to their office, that they'll be processing a report, and that the area director will look at it as well, okay, or a supervisor. And what will happen is this, basically, right, is that if OSHA is going to cite us, they'll cite us in one of a few different ways. So I want you to remember this, is let's say if an OSHA uh, inspection, and let's say today is, I'm going to give you an example. Today is March 30th, 2017. If the inspector leaves today, OSHA has 6 months to cite us. So basically, by September 30, we should be being cited. If they don't cite us by September 30, and then most likely we're not being cited. So they basically have 6 months from the inspection date in order to do that. Okay. And what will happen is when you get cited by OSHA, you will get a citation, you will get a penalty, and they would also advise us of the abatement status. So let's talk about those violations and citations, right, and penalties. And I'm going to show you a citation in just a moment as well, folks. So if you look at 2.3.1 violations, right? Basically, if we violate a standard, there'll be a proposed penalty that comes along with it. Well, the violations, they'll be categorized in one of a few, right? So these are the primary categories that they'll be categorized in. They'll either be an other than serious violation, right? And what are those? Those are violations affecting the safety and health, right? But they're unlikely to cause death or serious harm. So it might be more for like lesser injuries, right, or illnesses as well. And then the second one is serious violations. Those violations, they're probably going to cause a death, right? Or at least some serious physical injury. And the employee sure that does know about the hazard that's causing the violation sometimes. So that possibly could be a serious, right? Now, a willful violation, those violations, those are going to involve situations where the employer is going to intentionally and knowingly commit a violation, right, of the OSHA standards, and that they're aware of the hazards, right, and they're not making any reasonable effort to go ahead and fix the issue or keep the employees out of harm's way. So willful violations, basically, they're going to be divided into a few different sections, right? Willful, it's either going to be a repeat violation because they did it more than once. It's going to be a failure to abate. Basically, OSHA told us to fix the problem. They gave us a limited amount of time to fix the issue, and we still haven't done it. And then the third one is going to be the egregious violations, which basically egregious is, hey, they're doing it, they don't care, we're still at risk, and now we're going to put a bigger or steeper penalty on it or fine. Okay, so those are your three different types of types of willful violations. Okay. And then OSHA citations. What happens? Like I said, area director, right? Area director will go ahead and look at it. They may look at pictures. They may look at video that the OSHA inspector takes. They may take air samples if they did any type of swabbing or air monitoring out there. And they'll be looking at all the data that they've collected to determine what we're going to be cited for. And also not only what we're going to be cited for, but how much we're going to be cited for each violation as well. Okay. So that's how the citations will work. And like I said, we should plan on receiving them within 6 months of the inspection date if we're being cited. Okay. I noticed that many of them are running to the very end. Most of the ones that I see, and I'm about to show you right now, they'll say that the inspection date was so and so date, and 5 months, 5.5 months later, they're doing an inspection. So let me show you what they look like, right? So let me go ahead and go to an OSHA citation here. Let's see. Okay, this one that I'm pulling up, I think has a lot of has a lot of 1910, which is general industry, and then I'll pull up a construction one, folks. So this one, let's see. Let me go ahead and do something really quickly. All I'm doing is saving it, folks, so I can put it on a full screen. It's going to be a lot easier for me to put it on a full screen. Okay, so here you go, folks. Here is an OSHA citation, and this is what it looks like, right? So you'll get this in the mail. If you look at the very bottom, it shows page 1 of 24. So this citation went out to a company called Custom Alloy Sales, right? 34P, and then LLC. That's the name of the company. So if you look at the inspection dates on this, folks. The inspection dates stemmed all the way from September 9th, and they must have done some follow-up inspections because it shows inspection dates being multiples all the way from September 9th all the way down to January 29th. So they must have been coming back to this facility. And as you notice, the issuance date of the citation there was March 6, 2015, okay? The inspection site was in Kansas, and that's also where their corporate office was as well. So here's a copy of a citation. It goes on to tell you what your right to contest it is, what the employer rights are as well, what inspection activity, right data that may be considered as well. And then also the employees or unions have a right to go ahead and sit down with an informal conference. So does the employer as well. And then they'll get this. This is the certification of correction action worksheet. So basically, this is for the abatement. So for every citation that we get and we get penalized, we must do an abatement statement. So what happens is, if we have, and I'm going to show you in this document here, if we have, let's say, 6 citations in this document, I think this document is like 12 or 15 or something. But if we have 6 citations in this document, we must do 6 abatements. So for everything we get abated, citation on, we're also going to have to do an abatement on, okay? We'd be putting down the citation number, the item number as well, what date it was written on or created on, and then also we'll go ahead and put the method of abatement, right? Basically how we're fixing it as well. So here you go, folks, or by whom. So this is what a citation looks like now. This facility was right here. They were cited on 1910.119. And that's the PSM standard. That's the process safety management standard. This was a serious violation at $4,500. Okay, there's a recap of basically what happened. Employees were exposed to the release of chlorine compounds. Okay, so here you go. Here is first citation, second item. Okay, a serious hazard. Here's a third item. So if you look at it, right, you'll see each one of these, the employer's being cited on, right? $4,500, $4,500. What was that? 45,000. Let me see. $4,500. And as you see, it keeps on going on, right? Citation 1, item 7, 8. Look at them. We're up to item 9 now. So that's 9 penalties already that you see here, okay? And then, like I said, it's got the standard number here and what the standard number says, and then also an explanation of what they found. Okay, so just to give you an example, look at it. We're at 14, item 15. So this total citation was 16 items. So that means there were 16 citations in this. So there have to be 16 abatement statements done, which were these first statements that we saw. Let's see, excuse me 1 second. Right here, we have to do 16 of these. And there you go. Look at the total citation penalty for this organization. It was a total of $774,000, which was the total cost. Okay, so that gives you an idea of basically what the OSHA citation looks like. They'll give us an abatement period, basically telling us how long we have to fix each hazard as well. Okay. They'll go ahead and number out the dates for us, and they work with subject matter experts to determine how long it'll take for most of these citations to be done. And then some of them could be on the same dates that are due. Some of them could be different dates, just depending on how difficult or how complex they're going to be. Okay. All right, great, folks. So So if you look, that's what citation looks like. Let me show you one more before we move on. Okay, that's 1910. That's general industry. So let me show you one for construction now, since the majority of the people online are working more in the construction industry. Okay, so here you go. If you notice this one here, right? This one, the site was inspected on February 2nd, and the citation did not come until 5 months later, till July 22nd is when they were cited, right? Just shortly before the 6 month period. Company called Hassel Construction Company out of Houston, Texas. And if you look, same thing, all the employers' notification and right to uh, and the right to contest if they want to contest, or an informal meeting. Okay. Citation number. Excuse me 1 second. Let me go ahead and save this one as well, folks. Okay, here you go. So notice the employer's right certification of corrective action worksheet. There you go. First one was a serious hazard, right? $2,700. 1926 150. That's flammable liquids and firefighting equipment. Second one was 251, which is rigging. There was a rigging issue here. And basically what happened, let's see, did not have the permanently affixed durable identification stating size, grading, and capacity of slings. Okay. So that was a sling hazard. And then another sling. Let's see, it's sling there. Okay, now the 300, 1926 300. What are we talking about there? Is electrical hazards, I believe, if I'm not mistaken. And you see the price is 3,600, 4,500. Okay. These are for excavations. These are 651 right here. This is what I'm looking at. 1926-51 are related to instability of adjoining structures. We're talking about excavations, hazards. Okay, serious violation. So you see how the citations are going on and on. So that was citation number one, right? A total of 9, and then items, and then now the second citation. Let's see how many items. Total of 6 items, and look at the cost on this one, folks. $420,000, $420,300. That was a total citation for this organization now. So some of these citations nowadays, like we're saying, are getting significant in cost. Okay. So, and then you saw the abatement period statement at the very beginning. Let me go back to it. And as you saw, excuse me, you see serious, now willful. Look, right? Now willful. So that it may have been repeat. It may have been that they were that negligible on it. So no telling, right? Okay, so let me go ahead and save this. Oh, excuse me. I'm sorry. I already did. Sorry about that. Okay. All right, so there you go, folks. Now you see what the citations look like, okay? So now let's talk about penalties a little bit. So let's talk about what the new penalties are, because they just went through a significant hike. So let's go ahead and pull them up, okay? So I'm just going to Google, folks. Okay, so let's do OSHA fines. Okay, here you go, folks. So the fines recently, they went up significantly from what you see in the book. So if you go to the book and go to page 16.5, and you'll see that a serious and other than serious violation at the time was $7,000. Now they took roughly a 70% increase. They hadn't had one in many, many decades, an increase. So there you go. Now a serious violation is 12,675. So that's what it is now. And then willful or repeated could be anywhere from 2 to 5 to 10 times the original penalty. So as what you see is basically taking the failure to abate of the serious other than serious and basically multiplying it by 10 because that's the egregious multiplier. It can be added on to certain companies as well. So there you go. Okay. So you saw what I did. Let me go back. Right. All I did was go to Google OSHA fines, and that was the first thing that came up, folks. Okay. All right. Great. So focus inspection programs is basically what we're talking about. They may be looking for significant risk, right? What do they often look for in construction? Fall hazards, electrical hazards, caught by hazards, struck by hazards. The OSHA focus for, right? PPE. So those are just some fire hazards. So those are just some examples where they may be targeting on those specific types of items, like from scaffolds, forklifts, ladders. Okay, they may be doing for those specific targeted items. Okay, or at least the majority of their emphasis. So as far as effective, I'm at 311 now, folks. So as far as an effective written safety program, right? It's got to meet the OSHA standards, right? It's going to have to meet the general safety requirement provisions through OSHA that in subpart C. So basically, the plan, what does it have to include, right? It's got to have a project safety analysis. It's got to have an evaluation of subcontractors to conform with the plan. Supervision and training. It's going to have control of hazardous operations, documentation, employee involvement, and emergency responses. Okay, so emergency response. So at a minimum, it's going to have that. Also, what else is going to have? A competent person, right? And what is a competent person? A competent person is a person who's been trained to do their job. So if it's scaffold, it could be scaffold assembly and disassembly, right? If that's all we're teaching them to do, and that's what gives them their competency, we may wind up doing that. Okay, so I'm going to give you some examples. So let's say a competent person in scaffolds. Let's say competent person in scaffolds is going to be somebody who's been qualified and trained to oversee the assembly and disassembly of a scaffold and its daily inspections to make sure that it's compliant and safe for employees to access. So by training and employing qualifying a supervisor to be able to oversee the assembly and disassembly of scaffolds and then do daily inspections on them, could make that person the competent person. And what happens is that through that qualification, education, and training, and by the employer giving that supervisor or that manager or that line employee that written authorization to take prompt corrective action, that is what's ultimately going to give that person a competency level. Okay, so competent and qualified. Let's go to what the difference is, right, between competent and qualified. Competent versus qualified. Competent people, they qualified people basically through, and let me pull up the OSHA. Let me pull up where it says it. Okay, so it's OSHA. I'm doing competent versus qualified person. As you can tell, it's purple. I've done it multiple times, and I'm pulling up the letter standard interpretation right now of this. So this is what happens, folks. Right? This is what OSHA says. The definitions for a qualified person: they have to have a recognized degree. They have to have a certificate or extensive experience, right? And the ability to solve a project problems. So let's say somebody who designs a scaffold, they're going to have to be qualified. Well, let's say it's a 20-foot scaffold, 30-foot scaffold in height, right? They might have a degree, they might have a certificate, or they may know it off of extensive experience. It's always a possibility. All right. So and then competent person. What's competent person? Well, a competent person is going to have to be trained to their level. So they're still going to have to be qualified. A competent person is still going to have to be qualified to their level of training. So let's say, again, if it's a scaffold and if it's a supervisor that's overseeing the assembly and disassembly of a scaffold, they need to be qualified enough to know how to properly assemble and disassemble a scaffold, the hazards associated with it. And if we give them the authority to take prompt corrective action, that person has been qualified and is now a competent person on site. Okay. So same thing goes for rigging. The same thing goes for, like I said, scaffold building, fall protection, confined spaces, folks. And hot work. Okay. So the same thing goes for all of those. So that's one of the best ways that I can explain that. Okay. And that's why we need that competent person, because as you notice right here, where does it say it? Is that they have the authority to take prompt corrective action. Let's see. Right here, folks. This is what I was looking for right here. Competent person, right? One who is capable of identifying existing and predictable hazards in the surroundings or working conditions which are sanitary, right, hazardous, and dangerous to employees, and who has the authorization to take prompt corrective action to eliminate them. And that's why competent persons have to do our inspections on whenever they're being required on any type of rigging, confined space, aerial lifts, fall protection, okay, scaffolding, any of those. Okay, so let's go ahead and move on. And if you look at page 16.7, construction focused inspection guideline, right? So basically, just a lot of questions there, talking about the project safety and coordination, talking about is there a designated competent person, right? Is there a project health and safety program? It goes on to ask certain questions to see how we're going to, if we're meeting the standard or not, okay? If you read it, it'll keep on going. It asks us to start identifying hazards in the workplace, right? Whether we have a project plan or a work plan in place. Make sure we have certain documentation and procedures that are memorialized or that are in writing as well, right? And then the four leading hazards in construction. The four leading hazards in construction, you see it there, is falls, being struck by something, being caught in, under, or between machinery, equipment, or even soil like excavations, and ultimately um, electrical shock. So we've talked about this multiple times, and what are we talking about? We're talking about the OSHA Focus 4 or the OSHA Fatal 4. So let me go ahead and go to it. Okay, so here you go, folks, right? OSHA Focus 4, we're looking at, there we go, folks. We're looking at falls. We're looking at caught bys, struck bys, and electrical hazards, okay? Here you go. Here's a little bit better picture of it, of the icon. Okay, so falls, caught by, struck by, and electrocution, which are the four greatest ways that you can be harmed or killed in a construction site. Okay, all right, great. And then modified inspection procedures, right? If the company qualifies for focus inspections, the inspection process, it's going to be modified. The inspection is going to include the same 5 steps that are used on a regular inspection, right? What steps again? The presentation of the inspector's credentials, opening conference, right? Selection of representatives, like I said, that's probably going to be in the same step, and then walk around, and then the closing conference. Okay, but what's going to be the difference between a regular inspection and a modified inspection? It's going to be the opening conference. It's going to be included a broader review, right, of the safety documentation, and the walk around inspection is going to be limited. So basically, those modified inspections, what they're going to do is they're making sure that more of the policies are in place. And by assuring that more of the policies are in place and that facility is, is on that list of modified inspections, well, they'll have less audits in the field or less audits in the shop. Okay. Okay. So post inspection follow up. Right. I'm over at 4.0.0. If a violation is found, we need to record the problem and correct it. Right. If the problem's not fixed right away, the CHHO, the compliance officer, right, will likely schedule another inspection. Normal and normal follow up. Normal follow up inspection procedures. Right. So just biggest thing is making sure that we comply, making sure that we're doing the improvements and taking the corrective action that we do in order to make sure that our employees are protected. Okay, so reports to management and employees, right? Reports they often have to be prepared as soon as possible, right, so that nothing's overlooked. Um, Also, the report, what should it do? It should give management, right, a record of what the inspection covered. It should mirror what the CSHO had on file, right? It should also include documents that were reviewed by that compliance officer. What photographs did the compliance officer take? We might want to take the same exact photos that the compliance officer takes. It's like I often tell people, don't go shutterfly. Don't start taking pictures after pictures after pictures, because if we want to know what they have, we should only take the pictures that they have. That way, if there's anything that we're concerned about, we're trying to look at, we know we're looking at the same view or perspective that compliance officer used. Okay. Also, any noted violations. Violations corrected on the spot. They're going to take that into consideration. Had uh, if we had put our best foot forward and we're trying to go ahead and remove hazards, even though the inspector was already there, if they ask us to take any corrective actions, okay, and any outstanding violations that are also noted by the compliance officer, right? So these are all things that are taken into consideration. So the abatement and the abatement certification. So what are we talking about, right? We're talking about the abatement. What it is, basically, the definition of an abatement is that we're correcting the safety hazard, okay, that led to the citation. So abatement certifications, okay, it's going to be a written record, right, that states that the problem noted on the citation had been fixed. So let me go back to the citation. There we go. Here's the citation. And here's the notice of abatement, right? The corrective action worksheet that would be, as the employer would be filling out and doing each line. So for each violation, for each citation and or item number, we'd be doing an abatement statement, okay? And these abatements have to be done, just so you know, they're not always all on the same dates. They might give us some to fix in 2 to 4 weeks. They may give us some to fix in 8 to 8 weeks, some more to fix in 10 or 12 weeks, just depending on the severe nature of the time and what other corrective actions we have in place. Okay? So the biggest thing is to remember this, is that if you have a total of, between citations and item numbers, if you have a total of 6, you're going to be doing 6 abatements. If you have a total of 12, we're going to be doing 12 abatements. So, in addition to that, we have the rights to informal conferences, appeals, and hearings. Okay, if the employer believes that the citation is unreasonable, the employer could go ahead and ask for an informal conference. We've got to ask for that informal conference within 15 days of receiving the notice. Okay, if the informal conference, basically what it is to try to work out any disagreements first before there goes to any appeals or to any litigation. OSHA and the employer, that what they might do is they might make a settlement agreement, right, to resolve the dispute. Also, the primary goal is to protect workers, right, and to eliminate hazards. So the biggest thing, it's not about an income thing with OSHA. What it is encouraging and pushing on the employer to be able to better protect us and offer us better protections, right, in the workplace. Okay. So, in addition to that, the settlement agreement, it has to be posted. So if the employer does settle with the employees, it has to be posted. If the employer is not satisfied, right, after the informal hearing, the employer can go ahead and request a formal hearing. That has to be done by filing a notice of to contest within 15 working days from the receipt of the citation. So that's why it's imperative. As soon as you get a citation, hopefully none of us are cited because we're doing the right thing. But if our organizations were to ever get cited, the calendar and the clock move very quickly on these things. Okay, so also the matters, and then it's assigned to an administrative law judge, right? So what happens is you have courts and federal, state courts, and local municipal courts, and federal courts, state courts, and then local municipal courts. Well, you also have courts in administrative agencies like, let's say, Social Security or U.S. Department of Labor, right? So basically, U.S. Department of Labor has its own administrative law court. And what happens is that OSHA goes through the administrative law court, and that way, what happens is if we want to sue or if we want to complain, the first place we have to go ahead and file notice with, in that case, is not going to be a court. It's going to be an administrative law court, and we're going to notify OSHA first of our intention to do so. Okay. And then basically common affirmative defenses, right? Defenses that might be used is unpreventable employee misconduct. Maybe certain employees are trying to tank our program. Maybe we're having discipline issues. We're working through it and trying to either retrain employees or discipline them, and they're just constantly just just disregarding, right? And so we're having to determine what our course of action is going to be, or course of correction action is going to be. It could also be impossibility. Hey, you want us to do a certain corrective action, but we find that it's impossible, right? And we've got the data to show, we've got the events to show, and evidence that it's impossible to do what you're asking us to do. And then, of course, also the greater hazard. So if the corrective action that the standard recommended or by deductive reasoning is the direction we should have gone, however, created the greater hazard or could have created that greater hazard, and then we may ask for an exception for that reason, and or to go ahead and work against that citation, right, in order to try to either get that citation waived or to get it minimized. And then also multi-employer work sites. Maybe it's another employer that caused the hazard. Our employees maybe tried to stay away, or maybe tried to, stay out of harm's way, and ultimately we're doing and asking for some consideration and some courtesy because we weren't the party that was actually in violation. But however, it did possibly affect our employees. And then multi-employer work sites, right? Basically, what are multi-employer work sites? It's when various companies are working on the same site at the same time. Okay, so it's where several employers are working. Right, I'll give you perfect examples of turnaround in refineries. Right, we may have a general contractor, and then we got a bunch of subs working in the same work site. A lot of times on highway construction, also we have the general contractor and work subs, or in buildings like hospitals, hotels that are being built is a perfect example as well. So what's going to happen is that it's a large project, right? And during that inspection, several employers can be cited, right? And what's going to happen is this: is that the employer who's the employer, who any employer whose employees are exposed to a hazard is going to be cited. They're going to be cited under as an exposed employer. So let's say that let's use an example. Let's say I have a missing guardrail off of a mezzanine or a balcony. If my employees are up there and they're exposed to that to that broken guardrail, whether my company broke it or not, I'm going to be an exposing employer because I'm exposing my employees to that hazard. Also, we have the employer who actually created the hazard, right? That would be the creating employee. Let's say that a company did whatever they damaged with a boom truck or something. They were moving sheetrock or something, and they broke the guardrail. Well, that's why it's broken now. So that employer may be working there as well, and they're going to wind up being the creating employer. They created the hazard. Okay. Also, the employer is responsible, right? Who's responsible for the contract or the actual practice of safety and health conditions on a work site. So what are we talking about usually there? We're usually talking about there is usually it's called the controlling employer. And what it's going to be is it's going to be maybe the general contractor or the prime contractor or an upper tier subcontractor that has subs working underneath them still. And then, of course, the employer who's responsible for correcting the hazard, and that's going to be called the correcting employer. And that's whoever sends someone up to go ahead and get rid of that hazard and goes ahead and puts the protective measures back into that guardrail so that the hazard's now been eliminated. Okay. And then the proven affirmative defense, right, in the multi-employer work site, the employer has to prove all five elements, right? The five elements of this, right? That the employer did not create the hazard. We weren't the one that knocked the guardrail off the balcony of the mezzanine, right? The employer did not have the responsibility or the authority to remove the hazard. Basically, we didn't have the authority to remove the guardrail or to gate it off or fence it off or caution tape it off or whatever. The employer didn't have the ability to correct or remove the hazard like we just talked about. The employer did not have the responsibility, right, or the authority to remove the hazard either, right? And so they didn't have the ability, and then didn't have the authority. And then the employer can demonstrate that those responsible for controlling, right, or creating the hazard have been specifically notified of the hazard. So basically, what happened in this situation is that if the employer can demonstrate, right, that the person responsible for controlling or correcting the hazard have been specifically notified, well, it's going to take a little bit of pressure off of us, okay? And then the employer has instructed his or her employees um, to recognize the hazard, right, where necessary, and then he informed them how to avoid the dangers associated with it. So he's basically, or she's basically telling them, hey, you got a significant risk in your area, so we need to go ahead and be cautious or pull employees off of that area or section, okay? And then, of course, last of all, OSHA also offers voluntary consultation services. So with voluntary consultation services, basically OSHA, what they're doing is they're offering compliance assistance, right, to small and mid-sized businesses. So they're offering consulting to small and mid-sized businesses, and it's basically a full consultation service. They'll come out, they'll do worksite assessments for us, they'll look at our safety plans, tell us what they think, make recommended changes, change recommendations, right? It can cover the entire work site, right? Or maybe it's limited to a few specific problems. Now, the compliance assistant program, what happens is it kind of works like that, like the inspection division, right? Like the compliance division. But what they do is they give us a little bit of courtesy. So normally it's not cited if we're deficient. They're basically telling us to fix it, right? Now, if they continue to tell us to fix it and our company's not fixing it, and then our company can be cited. All right. But if we bring them in and they have to give us the first opportunity to go ahead and fix the hazards that they recognize. Now, if we don't fix them, yes, and then they can go to the from the consultant to the compliance department, and go ahead and we may start looking at potential citations, right? And then in addition to that is also if it's anything imminent danger, if it's immediately dangerous to life and health now, a significant fall, right? Let's say 18, 24-foot fall, and people might die. They might call in the compliance group immediately. Okay. But they do, like I said, they do offer consulting services. Let me show you where that is before we summarize and go ahead and close up this module. So I'm going back to OSHA's website, and all I'm doing is OSHA compliance, right? OSHA consulting. And here you go, small business on-site assistance, right? So you come in here and consultant resources or co-op programs and a consultant directory, right? So I'm going to come here, start choosing my state. There you go. And then you start going through the questionnaires. It gives you the phone number and everything else and the contact office. You contact the consultation office. Like I said, they'll come out and they'll help us, okay? So, alrighty, folks. Well, look, that's it for this for the 75216, right? For this module 16. So you see your review questions at the end of the module, and as always, if you can go ahead and complete those. So we're shutting this module down, folks. We'll go ahead and get the next the next two modules up as well. They should be going up tonight, which is ESH data tracking and trending, and then we'll have that's module 17, and then we'll have module 18, and and we should be wrapping up this book tonight from the way it looks, okay? And that's going to be environmental awareness. So if y'all need anything, everybody know the drill, right? I'm Doug Castro. Feel free to give me a buzz, shoot me a text, call me, email me, and I'm glad to answer any questions that need to answer. Biggest thing is we want to make sure that everybody gets a full grasp of all the subject matter, okay? Thanks, folks, for listening to this session. Bye.